Memorandum of Association MOA Section 4. Memorandum of Association is the fundamental document for the formation of the company, hence considered as its charter or constitution. Memorandum defines the relation of the company with outsiders because it enables all those who deals with the company to know what its power are and what activities it can engage in. The memorandum shall contain the following clause: Name clause, situation clause, also called registered office clause, object clause, liability clause, capital clause, applicable if company is formed with shared capitals, association clause or subscription clause, specifically drafted in case of OPC, and nomination clause, applicable in case of OPC. Section 4 of the Act, along with the relevant rules from the Companies Incorporation Rule 2014, provides for the requirement with respect to memorandum. Name clause. Section 41A, read with subsection 2 to 5. The name of the company with the last word limited in the case of a public limited company, or private limited in case of a private limited company. Application for reserving name for proposed company. A person may make an application in Spice Plus accompanied by fees as provided in the company's registration office and fees rule 2014 to the registrar for reservation of a name set out in the application as name of the proposed company. Resubmission shall be allowed within 15 days for rectification of defect, if any. Application for reserving the name for the changing name of existing company. A person may make an application using web service run, reserve unique name along with fees as provided in the company's registration office and fees rule 2014 to the registrar for the reservation of a name set out in the application as a name to which the company proposes to change its name. Resubmission shall be allowed within 15 days for rectification of defect, if any. Restrictions regarding names and use of words and expressions therein. Subsection 2 and 3. Subsection 2 states that the name mentioned in the memorandum shall not be identical with or resemble too nearly to the name of an existing company registered under this Act or any previous company law, such use of which by the company will constitute an offence under any law for the time being in force. Such use of which by the company is undesirable in the opinion of central government. This power of central government has been delegated to ROC. Further, subsection 3 provides, unless the previous approval of the central government has been obtained, a company shall not be registered with that name, which contains any word or expression that is likely to give the impression that the company is in any way connected with or having the protection of the central government, any state government, or any local authority, corporate or body constituted by the central government or any state government under any law for the time being in force, which includes words or expressions namely board, commission, authority, undertaking, national, union, central, federal, republic, president, Rashtrapati, small scale industry, Khadi and village industry corporation, financial corporation, and the like, municipal developmental authority, prime minister or chief minister, minister, nation, forest corporation, development scheme, statute or statutory, court or judiciary, governor, bureau, and the use of word scheme with the name of governments, state, India, Bharat, or any government authority or in any manner resembling with the schemes launched by central, state, or local government and authorities. Reservation of name. Subsection 5. Upon receipt of an application, the registrar may, on the basis of information and document furnished along with the application, reserve the name for a period of 20 days from the date of approval or such other period, provided in case of an application for reservation of name or for change of the name by an existing company, the registrar may reserve the name for a period of 60 days from date of approval. While allotting names, the registrar of the company concerned should exercise due care to ensure that the names are not in contravention of the provisions of the Emblems and Names Act 1950. It is necessary that registrars are fully familiar with the provisions of the said Act. An application for extension of reservation of names under Rule 9A of the Companies Rule 2014 can be made before expiry of 20 days. For another 20 days, total of 40 days, with fees of 1000, which may be further extended by another 20 days with fees of 2000. For another 40 days, total of 60 days with fees of 30,000. Cancellation of reserved name. Where after reservation of name it is found that the name was applied by furnishing wrong or incorrect information, then if the company has not been incorporated, the reserved name shall be cancelled and the person who has made the application shall be liable to the penalty, which may extend to 1 lakh rupees. If the company has incorporated, the registrar may, after giving the company an opportunity of being heard, either direct the company to change its name with a period of month after passing an ordinary resolution, take actions for striking off the name of the company from the register of the companies, or make a petition for winding up of the companies. Situation Clause Section 4 Subsection 1b. Situation Section 4 Subsection 1b requires the memorandum of company shall mention the name of state where the registered office is proposed to be situated. The situation of registered office is important from perspective of establishing the domicile of company for the purpose of determining jurisdictions in context to compliance, judicial aspects, physical aspects, and for many other purposes. Place at which the company's statutory books must normally be kept. In case of a public company, general meeting also required to be conducted at registered office or in the city where it is situated. Act as the address to which notices and other communications can be sent. A company shall, within 30 days of its incorporation and at all time thereafter, have a registered office capable of receiving and acknowledging all the communications and notice as may be addressed to it. Section 41C Object Clause and Doctrine of Ultra-Vires. Section 41C requires the memorandum of company shall state the objects for which the company is proposed to be incorporated and any matter considered necessary in furtherance thereto. Specified IFSC public companies and IFSC private companies shall state its object to do financial service activities as permitted under the Special Economic Zone Act 2005, read with Special Economic Zone Rules 2006, and any matter considered necessary in furtherance thereof, in accordance with the license to operate from International Financial Service Center located in an approved multi-service special economic zones granted by the RBI, SEBI or IRDA. The company can't depart away to do anything beyond or outside its object stated in the memorandum, and if any act done beyond that will be ultra vires and void. Same can't be ratified even by the assent of whole body of shareholders. Act ultra vires is to the authority of the director may be ratified by the company. Articles provide for regulations inside scope established by MOA. Hence, act beyond ultra vires, the articles can be ratified by the shareholder provided the relevant provisions are not beyond the memorandum. To illustrate, one of the director is authorized to issue check of rupees 10,000, but he issued for 12,000. Company can ratify so. It is worth nothing here that memorandum of company can be altered to widen the scope of object, but such alteration shall have prospective effect only, not the retrospective. Hence, an act once ultra vires remains so ever. A company may do anything which is incidental to and consequential upon the objects specified, and such act will not be an ultra vires act. To illustrate, for trade, one have rent or own a building, issue invoices, make and receive payments. Essence of doctrine of ultra vires. The doctrine of ultra vires is meant to protect shareholders and the creditors of the company or anyone who deals with the company. Invocation of doctrine of ultra vires. The doctrine of ultra vires was first inculcated by the House of Lords in a classic case of Ashbury Railway Carriage and Iron Company Limited versus Ritchie. The memorandum of company in the said case defined its object. Thus, the objects for which the company is established are to make and sell or lend or hire railway plants to carry on the business of mechanical engineers and general contractors. The company entered into a contract with Messrs. Ritchie, a firm of railway contractors, to finance the construction of a railway line in Belgium. On subsequent repudiation of this contract by the company on the ground of its being ultra vires, Ritchie brought a case for damages on the ground of breach of contract, as according to him the word general contractors in the object clause gave power to the company to enter into such a contract, and therefore it was within the power of company. More so because the contract was ratified by a majority of shareholders. The House of Lords held that the contract was ultra vires in the company and therefore null and void. The term general contractor was interpreted to indicate as the making generally of such contract are as connected with the business and mechanical engineering. The court held that if every shareholder of the company had been in the room and had said that is a contract which we desire to make, which we authorize the director to make, still it will be ultra vires. The shareholders cannot ratify such a contract as the contract was ultra vires the object clause, which by act of parliament they were prohibited from doing. Effect of doctrine of ultra vires. The key effect will be as under. Whenever an ultra vires act has been or is about to be undertaken, any member of company can get an injunction to restrain it from proceeding with. Neither party can sue for enforcement or specific performance of such agreement. Reason explained under head constructive notice. Liability clause section 41D requires the memorandum of a company shall state in case of a company limited by share the liability of its member is limited to the amount unpaid, if any, on the share held by them, and in case of a company limited by guarantee the amount of up to which each member undertakes to contribute to the assets of the company in event of its being wound up while he is a member or within 1 year after he ceases to be a member, for payment of debt and liability of the company or of such debts and liabilities as may have been contracted before he ceases to be a member as the case may be, and to the cost, charges, and expenses of winding up and for adjustment of rights of the contributors amongst themselves. Those shareholders who are a member of company at the time of winding up are included in List A. They are primarily liable for making payments to the company at the time of its winding up, while List B consists of those persons who were the member of company during the 12 months preceding the date of winding up. B list contributors are liable to contribute if the amount realized from contributors of List A is not sufficient to discharge the liability of the company. Modern Furniture Limited, a company limited by shares, having shares capital divided into shares with face value of rupees 10 each, out of which rupees 8 is called up Mr. Singh, who is having 200 shares paid up rupees 8 on each of the share he holds, while Mrs. Sarla owns 100 shares paid up of rupees 10, rupees 2 in advance, whereas Mr. Sanju owing 250 shares paid up rupees 6 per shares, 2 in arrears per shares. Liability of Mr. Singh, Mr. Sarla and Mr. Sanju shall be maximum up to rupees 400 nil and 1000 only respectively. Capital Clause Section 41E 1 requires in the case of a company having a share capital, the memorandum of company shall state the amount of share capital with which the company is to be registered, that is authorized or nominal capital, and the dividend thereof into shares of a fixed amount, that is face value and number of shares, and the number of shares which the subscriber to the memorandum agrees to subscribe, which shall not be less than 1 share. Subscription Clause Section 41E2 requires the memorandum of a company shall state the number of shares each subscriber to the memorandum intend to take, indicated opposite of his name, in the case of a company having a share capital. Nomination Clause only in case of one person company. Section 41F requires the memorandum of a company shall state the name of the person who is in event of death of the subscriber shall become the member of the company in case of one person company. Note: this provision is corresponding to first proviso to section 3.1 already discussed earlier in this chapter. Forms and schedules related to memorandum. Subsection 6. The memorandum of company shall be in respective forms specified in Table A, Table B, Table C, Table D and Table E in Schedule 1 to the Act as the case shown in figure. Table A, Memorandum of Association of Company Limited by Shares. Table B, Memorandum of Association of Company Limited by Guarantee and not having a share capital. Table number C, Memorandum of Association of Company Limited by Guarantee and having a share capital. Memorandum of Association of an unlimited company and not having a share capital. And Table E is Memorandum of Association of an unlimited company and having share capital. As per Section 399 of the Act, a memorandum is a public document. Consequently, every person entering into a contract with the company is presumed to have the knowledge of conditions contained therein. As per Section 4, any provisions in the memorandum or articles in case of a company limited by guarantee and not having a share capital shall not give any person a right to participate in the divisible profit of the company otherwise than as a member. If the contrary is done, it shall be void. Articles of Association AOA Section 5. Actually, Articles of Association of a company contains internal rules and regulations of the company. It is complementary to the memorandum and together gives effect as charter of the company. Articles establishes a contract between the company and the members and between the members inter se. This contract governs the ordinary rights and obligations incidental to membership in the company. Section 5 of the Companies Act 2013 and Rule 10 and 11 of the Companies Incorporation Rule 2014 seeks to provide the contents and model of Articles of Association. The provisions are stated below. Contents and matters to be included. The Articles of Association of a company shall contain rules and regulations for management of company, such matters as may be prescribed by Rule 11 of the Companies Incorporation Rule 2014 refers to the matter specified in the model form given under Section 1 to the Act. However, a company may also include such additional matters in its articles as may be provided or considered necessary for its management. Provision for entrenchment. Subsection 3 to 5. Entrenchment is the chronic or deep-rooted fact of an attitude habit or belief that is firmly established or accustomed. Therefore, it is difficult or unlikely to change. To illustrate, men don't cry. Entrenchment may be possible for processes as well as procedures in both ways. That processes are so well established it becomes difficult to change them or make process of change so rigid that processes become well established. Students, here we are studying the word entrenchment with the sense of making the process of alteration in articles more difficult. In order to enhance the protection, usually an article of association may be altered by passing a special resolution, but entrenchment makes it more difficult to change the articles in manner specified ahead. Articles may contain provision for entrenchment. The articles may provide that specific provisions contained in it may be altered only if conditions that are more restrictive and harder than those applicable in the case of a special resolution are met or complied with. Manners of inclusion of entrenchment provisions, subsection 4. The provision for entrenchment shall only be made either on formation of a company or by an amendment in the articles agreed to by all the members of company in case of a private and by a special resolution in case of a public company. Summary of section 4. Timing of entrenchment. At formation or after coming in existence for private company, all members should agree for the entrenchment, and for public company, special resolution is required. Notice to the registrar of the entrenchment provisions. Subsection 5 read with Rule 10 of the Companies Incorporation Rule 2014. The company shall give notice to the registrar of entrenchment provisions included in article in the Spice Plus along with the fees as provided in the company's register office and fees rule 2014 at the time of incorporation of company, and in case of existing company in form number MGT 14 within 30 days from the date of entrenchment of the articles along with the fees as provided in the company's rules registration and fees rules 2014. Model form of article. Subsection 6 provides that the articles of company shall be respective forms specified in table F, G, H, I, and J in schedule 1 to act as specified in the figure. Such forms are called modal forms. Further, subsection 7 provides leeway to company in adopting all or any of the regulations contained in the modal articles applicable to such company. Table F for articles of association of company limited by shares. Table G, articles of association of the company limited by guarantee and having a share capital. Table H, articles of association of a company limited by guarantee and not having a share capital. Table I, articles of association of a company unlimited company and having share capital. And Table J, articles of association of an unlimited company and not having share capital. Students are advised to take note. Subsection 8 provides that in case of any company which is registered after the commencement of this act, in so far as the registered articles of such company do not exclude or modify the regulations contained in the modal articles applicable to such company, those regulations shall so far as applicable be the regulations of that company in the same manner and to this extent as if they were contained in the duly registered articles of the company, either exclude or modify expressly or else it applies what stated in model applicable to company. Subsection 9 restrict the scope of section to the articles either registered or amended under this act. Hence, no provisions of this section 5 shall be applicable to articles registered under previous company law provided not amended under this act.